When you die, if your bank account is only in your name, the bank will freeze it. Not later, not after paperwork, immediately. And most families don't find out until they walk into the bank with a death certificate and walk back out with no access to a single dollar. At that moment, nothing goes in, nothing comes out, auto pays stop, bills stop, funeral expenses don't. And that's when families realize this isn't a money problem, it's an estate planning problem. When a bank account is frozen, it is frozen completely. No withdrawals, no deposits, no transfers. If pension checks are scheduled to hit the account, they may be sent back. If Social Security was still pending, it may be returned. If utilities, mortgages, insurance premiums, or car payments were on the auto pay, they stop. Life keeps moving, but the money does not. Now, people always ask me, how would the bank even know that I passed away? There are a few common ways. Sometimes the Social Security Administration stops monthly benefit payments. Sometimes a pension administrator flags the account. And very often, a well-meaning child or spouse walks into the bank with a death certificate and asks for access. That's when the bank manager very politely says, "I'm so sorry for your loss. Your name is not on the account, but thank you for letting us know." Account frozen. And once that happens, the bank will keep the account frozen until it receives a court order telling it exactly what to do. Banks do not want the responsibility of deciding who gets access, so they wait for the court. Now, let me pause here because this is where a lot of people say, okay, but what if there's not much money in the account? Maybe a few $1,000s or, $10,000, $15,000. Do I really need to worry about probate over that? Or can I just get it since it's a small amount? Here's the rule most people don't know. Probate is not triggered by the size of the bank account alone. Probate is triggered by the size of your entire estate. Most states have what's called a small estate threshold, and that threshold is not very high. In many states, it's around $75,000. In some states, it's even lower. In Florida, that threshold is lower than most people expect. So if your entire estate, your home, your car, your accounts, everything combined, exceeds that threshold, even a small frozen bank account can force the entire estate into probate. It doesn't matter if the account only has $3,000 in it. If it's titled the wrong way, probate is almost guaranteed. Another question I hear all the time is, well, what if my spouse is on the account with me? Legally, that's called joint ownership with rights of survivorship. And yes, that is better than nothing. If one spouse passes away, the surviving spouse can usually continue using the account as normal. But here's the question most people don't ask. What if both of you pass away together? A car accident, a medical emergency, a sudden event. If there are no other names on the account and no other instructions tied to it, the account freezes and we are right back in probate court. At this point, let me just properly introduce myself. I'm attorney Otto, a Florida estate planning attorney, and I see this exact scenario play out all the time. Families are shocked, not because they did something wrong, but because no one ever explained how bank accounts actually work when someone dies. So let's talk about how to avoid this. There are two primary ways to prevent bank accounts from causing probate. And bank accounts are unique because they allow both options. Option one, a revocable living trust. With a revocable living trust, you retitle your bank account into the name of your trust. Once that happens, the account is no longer owned by you personally, it's owned by the trust. That means when you pass away, there is nothing for the court to supervise because ownership was already transferred during your lifetime. Your successor trustee steps in immediately and continues managing the account. No court order, no delays, no frozen funds. The biggest advantage of a trust is control. With a trust, you can decide when beneficiaries receive money, how much they receive, whether distributions happen all at once or in stages, whether funds are held back for minors, whether distributions depend on maturity or responsibility. For example, you can structure distributions so that a child receives part of their inheritance at age 30, another portion at age 35, and the rest later on. Or you can leave distributions to the trustee's discretion. Or you can delay distributions entirely. When a bank account is titled in the trust, the money becomes subject to all of the rules inside the trust document. That level of control simply does not exist with a basic beneficiary designation. Now, to be fair, there are practical downsides to titling your assets, or your bank accounts rather, in the trust. Some banks are not very trust savvy. They require more paperwork. They move more slowly. Some payroll services won't allow direct deposit into trust accounts, although most of them do, so check it out before you decide against it. Online transfers can also sometimes be clunkier. International transfers can require additional documentation. Those are real considerations, but they don't outweigh the benefits. They just mean the trust needs to be structured intelligently. Now, let's talk about option 2, payable-on-death beneficiaries, the second way to avoid probate. It's by adding pay-on-death beneficiaries to your bank accounts. These are often called POD. Some banks call them transfer-on-death or TOD. This is done directly through the bank. You fill out a form, you list one or more beneficiaries, and when you pass away, the bank releases the funds directly to them. No court involvement. This method is easy to set up, familiar to banks, friendly for payroll and autopay, seamless for daily banking, but it comes with major limitations. One in particular: when a POD account pays out, it pays out everything at once, one lump sum immediately. There are no age restrictions, no guardrails, no delayed distributions. And for some families, that's perfectly fine. But for others, especially families with younger beneficiaries, that can be risky. Too much money too quickly can create problems. This is why many clients choose a hybrid approach. The best of both worlds strategy is what I call it. Here's what that looks like in practice. You keep your day-to-day checking account in your personal name for convenience. You add pay-on-death beneficiaries to that one, to the day-to-day account, and you keep a very low balance in it. Then you open a separate bank account in the name of your trust. You are still the trustee, you still have full control, you can transfer money freely, but larger balances, savings, reserves, long-term funds live inside the trust account where all of the trust rules apply. If something happens to you, the personal account passes easily to beneficiaries. The trust account flows seamlessly under the terms of the trust. No probate, no court, no panic. Now, one last word of caution. Beneficiary designations must be reviewed regularly. If a beneficiary predeceases you or becomes incapacitated or no longer reflects your wishes, the bank may not know what to do. And when banks don't know what to do, they freeze the account and wait for the court. So here's the bottom line. Probate is not caused by death. Probate is caused by poor planning and poor coordination. Bank accounts are one of the easiest places to fix this. With proper planning, your money stays accessible, your family stays protected, and the court stays out of your affairs. If you're watching this and thinking, I don't want my family dealing with frozen accounts and probate, that instinct is exactly right. I help Florida families structure their accounts every day. And if you have a question you'd like me to answer in a future episode, drop it in the comments. I'm Attorney Otto. Plan wisely, live confidently, and I'll see you next time.